Claimant asked for a new physician in Tennessee. Claimant got it. And later, you know, obviously there was some time that passed, but later the employer carrier sent a written deauthorization to the Florida doctors. It seems to me that that all worked the way it was supposed to.
Well, but that's the point I'm trying to make, perhaps not successfully, but it really didn't work the way it's supposed to. The way it's supposed to work is this doctor's authorized, then they're supposed to deauthorize the other doctors at the same time. That's what the statute says, 13-2F.
So anytime it's not mailed out at the exact same time, it doesn't take. I mean, I just can't believe that the whole statute rests upon a claims adjuster's timing of a letter deauthorizing. I mean, I don't think that that's the magic potion.
It's more than that, Judge. It's not just that the letter didn't go out. It's that after the claimant didn't go to Dr. Workman and they got the petition asking for a change of physician dismissed, the claimant went back to those doctors who remained authorized, and the carrier paid for it.
And there's nothing wrong with that. I mean,
well, the thing that's wrong about it is then they deauthorize them afterwards without any statutory authority. As the case stands, the way the case stands at the time those doctors were deauthorized in July of 2009 is this. No request for a change of physician is out there by the claimant, none at all. The 3 Florida doctors are still authorized doctors.
Well, let me ask you a hypothetical. Let's say that the claimant does his one-time change request. It goes to the carrier. He has an appointment 4 days later with the authorized treating physician. He makes his appointment as he should. But prior to him going to that appointment, they had, in fact, sent out the letter. They told him who the new doctor was and when his next appointment would be. So, therefore, he has the new doctor. But after he has the new doctor, he has gone to the old doctor, and they still paid for the old doctor. Would you then come in and say, look, you didn't give me my change within 5 days, and so, therefore, I get to pick out who I want? Or would you say they gave it to me within 5 days, and they also paid when I showed up afterwards?
Are you asking about whether?
I mean, I just don't believe that there's any prohibition against 2 authorized physicians, obviously, you know, overlapping. And I'm just curious about the magic of the timing of the letter.
All right. Let's say there's 2 authorized doctors. Let's go there. What right do they have to unilaterally deauthorize one of them?
Okay, you're down below 3 minutes.
Thank you.
May it please the Court. Good morning. My name is Jennifer Kennedy, and along with Samuel Cooley, I represent the employer carrier, Florida Power Corporation of Broadspire. As this Court is aware, the issue today is whether the JCC erred in finding that deauthorization of the claimant's Florida-based physicians was appropriate. And a key to that, as Judge Wolf, you've pointed out, in fact, is the claimant moved to Tennessee. He then specifically requested that he receive treating physicians in Tennessee, where he had now relocated permanently. The carrier located Dr. Burns, who is to treat the claimant for his orthopedic needs, and also Dr. Workman. The claimant failed to attend a appointment with Dr. Burns, then failed to attend 2 appointments with Dr. Workman, both in February and in April. And the appointment with Dr. Burns was in September. Now,
I guess it comes down to is when does the authorization and deauthorization process, when is that completed? And there's appealing in Mr. McCabe's argument is that if you look at the statute, when both letters are done, the authorization and the deauthorization, at least we have a clean period of time, and then we as a court don't have to get in the middle of all this mix-up. What you're arguing here seems to be we're going to go by on a case-by-case basis and get in the middle of it, and we're not sending out any clear message of when the process ends. Help me there.
Well, Your Honor, I think there still can be a bright-line rule, and I think actually this Court has set forth that rule in Cal Covens, partially, as was cited by the claimant, that deauthorization is appropriate if the JCC finds that there was sufficient grounds to deauthorize the physician.
Okay, I'm not asking about the appropriate, whether it's valid or not.
When it actually occurs.
But when it actually occurs. And you said there's a bright line rule for that. Tell me what that is.
Well, I may have misunderstood your question, Your Honor. I thought you were referring to whether it was appropriate to deauthorize.
I'm not talking about the appropriateness now. I'm just talking about when the process is completed.
Here, claimant requested these physicians. The physicians in Tennessee were then authorized. It's correct. I mean, the record is clear that the letter officially deauthorizing the Florida physicians was not mailed out until the carrier became aware, wait a minute, he requested these Tennessee physicians, he's moved to Tennessee, but now he's traveling 700 miles one way, so 1,400 miles round trip to see Florida physicians. They paid for that treatment, but then that's when the carrier said, okay, well, no, when we authorize these treatments, these physicians in Tennessee for treatment, that is what you requested. We've authorized that. These physicians in Florida now, it's not appropriate for you to continue to see these physicians in Florida when we've already authorized these physicians in Tennessee that you specifically requested. And then that's really kind of the crux of the situation that we have. There was a lot of discussion about the petition for benefits and that the carrier had the petition for benefits dismissed. But I think it's significant to recognize that the petition for benefits was not dismissed on the merits. In other words, the employer carrier did not argue, no, you're not entitled to Tennessee physicians. Rather, it was trial counsel failed to confer and make a good faith effort to resolve the issue. That is why the petition was dismissed. But the carrier still recognized, okay, he's moved to Tennessee, he wants Tennessee physicians, we're going to give him Tennessee physicians because that just makes sense.
Well, getting the PFB dismissed also saves your client attorney's fees. In other words, if they don't follow the rules to get
Sure. Yes, Your Honor. Exactly. But that's why the rules.
So we can give the claimant what he's entitled to, and we don't have to pay fees if we get it dismissed because they didn't do it the way they were supposed to do it.
That would be an effect of that. Yeah, certainly, Your Honor. But it doesn't negate. I guess my point is it doesn't negate the fact that that's what was wanted. I mean, clearly the record is clear. The claimant wanted these Tennessee physicians. He then had appointments lined up and never even bothered to go to see the physicians. So this isn't a situation where the claimant decided, well, I went to see Dr. Workman and I found out he's got, 100 malpractice suits in the last year. I don't want to treat with him. I don't feel, he didn't even try. He didn't even try to see him. He didn't seek out the treatment. He simply said, no, I changed my mind. I don't want to. I want to drive 1,400 miles or travel 1,400 miles to see these Florida physicians. And there's simply no basis in Florida law to allow the claimant to continue to treat with Florida physicians when he has relocated to Tennessee. The claimant has cited Cal Covens. If we do get to the question of whether the JCC, competent substantial evidence supports the JCC's findings, clearly there is competent substantial evidence in the record to support the deauthorization of the Florida-based physicians in this case. The Cal Covens case, which is really the only case, it's from 1986 from this court, that addresses this sort of issue where there was a claimant who moved out of state and sought treatment, continued to seek treatment in Florida. The Cal Covens simply said that the travel expenses alone are not a sufficient basis for deauthorization. Here, the record indicates that there was evidence presented that it was much more than simply travel expenses that are the concern.
So your argument is that because he moved 700 miles away, you have a right to give him a physician closer to his home, even if he is very comfortable with his Florida physicians and had never requested a change?
If the record demonstrates good cause to, yes, Your Honor. And I think here, the only guideline we have is Cal Covens.
What is the good cause here other than the travel expense and potential liability for traveling?
Your Honor, Mr. Brown, Dale Brown, who is testified on behalf of the employer carrier during the final hearing, has over 15 years' experience as a claims specialist. And he presented testimony that he has experience with, while he admitted he did not have experience with claimants who had moved out of state and tried to continue treatment in state, it appears that's simply not something that happens very often. But he does have experience with claimants who had moved out of state and then received treatment out of state. He had experience with claimants who, as the claimant in this case, receives ganglion blocks. It's like steroid injections, nerve blocks. And he testified that there is a concern that if the claimant is receiving nerve blocks, ganglion blocks, that he should not be traveling a great distance shortly afterwards, and that there would be concern for his care and possible relapse, possible exacerbation of injuries. So that's one additional concern. There is also the concern, as Your Honor pointed out, that there's a significant difference between traveling from Zephyr Hills to Tampa and traveling from Tennessee to Tampa.
But doesn't Cal Covens at least impliedly deal with that other issue of potential injury on the way?
I don't think so, Your Honor. Honestly, I think Cal Covens really talked about the mileage reimbursement and expense. It's not, I mean, I guess if you look at them, kind of everything's under the umbrella of expense.
But you know, it's kind of tied. If said the claimant is entitled to go, you know, come this distance for a physician, impliedly, you know, they're saying, you know, we understand all this, you know, the mileage and everything else.
But what's not clear, Your Honor, in the opinion is whether the actual concern about injury during the travel to and from and the fact that, I mean, even if it is not a car accident, I mean, even if it's simply driving a long distance, you know, hurts his back or, you know, anything of that nature, any injury that would occur in that travel would be compensable. And I think that does go to more than mere travel expenses. I think travel expenses.
We've allowed claimants to change their physician because the travel might aggravate their injury. I mean, correct?
Absolutely, Your Honor,
even when
yes.
the employer carrier didn't want them to change.
Absolutely. And to a certain extent, this is sort of the inverse of, you know, what this Court's already held, which is that the carrier can't require the claimant to travel outside his community to receive care.
If there were health issues.
Correct, Your Honor, yes. So it's sort of I mean, this is kind of the inverse of that, well, the claimant, if there's, you know, treatment closer, that logically is going to benefit the claimant because he's not traveling this distance with the treatment he's receiving. And the JCC had all of the claimant's medical records in the file, was able to review those, knew that he had had these ganglion blocks in the past. He, in fact, had said he wanted them in the future, that they helped him, and he hoped to get them again. So all of this sort of is more than mere travel expenses.
No, I understand the blocks. I mean, that's obviously an issue that was not dealt with in Cal Covens, but I'm a little concerned just about the possibility of injury on the trip.
Yeah, I understand that, Your Honor. And I guess what I'm saying is it doesn't appear that in Cal Covens the Court did discuss travel expenses, whether the Court considered potential re-injury or potential injury or additional liability within the scope of travel expenses. The Court may have. To me, it's not clear.
In Cal Covens, is it a total prohibition to ever consider the expense, or is it that expense by itself is not enough?
Exactly, Your Honor. No, it's expense by itself is not enough. So I'm saying we have the expense, which, exactly, Cal Covens did not say expense cannot be a consideration, but merely, and it kind of makes sense. They don't want the carrier to say, well, no, I don't want to pay. You know, there needs to be more than just I don't want to pay. Well, here, there certainly was more evidence presented to the JCC beyond simply I don't want to pay. And it also raises concerns, and you know, not necessarily with this case, because like we said, it's 1,400 miles approximately between Sayersville and Tampa. But what happens if the claimant decides he wants to move, you know, it's extreme, but to Alaska or to Hawaii or to, you know, anywhere, California, and say, well, no, I'm still going to travel. And the fact that the claimant has not yet requested reimbursement really is irrelevant. I mean, that was in the brief, and it's been discussed as sort of well, you can't, you know, carrier can't rely on that because we've never asked for it, but they still can.
But what about the argument? I understand you're making a logical argument here, but what about the argument Mr. McCain makes? The statute says deauthorization takes place for these purposes. And this is, you know, workers' comp is a creature of statute.
That is correct, yes.
And even though we think you're making a great argument, maybe this is an argument that should be made to the legislature.
Your Honor, I would disagree. I think if you look at 440.13.2d specifically discusses lack of recuperation or failure to progress as being a reason for deauthorization. 440.13a)(b), 8th B, discusses overutilization. But the statute does not say deauthorization of physicians is limited to only these two scenarios. Rather, it sets forth what the procedure and what needs to be done in those two specific instances. And it can be read that those sections are providing guidelines and the requirements in those specific instances. But it does not negate the case law that deauthorization may still be appropriate in other situations. And in fact, since the statutory change, this Court in City of Bartow v. Brewer, which was a 2005 case, cited language from Stuckey v. Eagle Pest Control, where the Court actually stated that if there is deauthorization, and it was not for overutilization, it was not for failure to progress or lack of recuperation, the Court said the focus should be on the question of why an authorized physician should no longer provide care, thereby severing the established patient-doctor relationship. So that relationship still has to be considered and certainly still has to be, as a factor. But this court in 2005 at least certainly recognized, well, this is still good law. And in the initial brief, the claimant, acknowledges that this court has held that since the amendment to the statute. And then more recently, in 2009, in Carmack versus State of Florida, Judge Benton, in a dissenting opinion, so it was not the majority opinion of the court, but in the dissenting opinion, again cited that language. So the language allowing for deauthorization if the JCC finds that there was a reason that the carrier should, or that the doctor should no longer provide care remains good law.
And you mentioned that it's a creature of statute. I mean, one of the purposes of Chapter 440 is to keep cost low, correct?
That is correct, Your Honor. Yes.
So, I mean, the cost consideration by the JCC is not, I mean, you said it wasn't dispositive, but as a factor, it would fit into the overall statutory scheme.
Absolutely, Your Honor, which is why it makes complete sense that the JCC would be allowed to consider other issues other than simply overutilization or failure to recoup. And this is, I think, the, perfect example of a situation where cost potentially could run rampant. I mean, it is quite possible, and granted, it's speculation, but it's quite possible that the claimant could end up saying, okay, I need to fly because I can't drive. Okay, well, now the carrier's paying for flights back and forth. As I said before, there's nothing stopping the claimant from moving across country, moving to Hawaii. All of these things are factors, and if the JCC is not allowed to consider these things, it is wholly inconsistent with the purpose of the workers' compensation statute and would create this exorbitant costs. And again, the fact that the claimant has not yet sought those costs isn't the point. The point is they're there. It's there. The claimant can file a petition for benefits tomorrow seeking expenses for the travel that he made previously to his Florida physicians when the Tennessee physicians were authorized. The fact that he hasn't done it yet isn't the point. The point is the expense is still there, and that is still something the carrier is paying for. So here, Your Honor, the record evidence clearly shows that there was competent substantial evidence supporting the JCC's decision that the claimant who was moved to Tennessee, requested treatment in Tennessee, received treatment authorized physicians in Tennessee, simply should not be allowed to continue to travel to Florida at the carrier's expense and at additional risk to himself to continue to receive care in Florida. Therefore, we respectfully request that this Court affirm the order below. Thank you.
Thank you.
If workers' comp is a creature statute, there has to be a statutory basis for what they did, and there's not. If you look at the situation at the time that they deauthorized these physicians, there was no pending request for a change of physician, and there's no statutory basis that they did so. Now, in my brief, I'm not sure. There's two mentions about prior case law. The Stuckey case is based on the 1985 statute that specifically states you can change physicians if the judge finds that there's good cause to do so. It's cited in Judge Benton's dissenting opinion in Carmack, but it is in the dissenting opinion, and then it is mentioned in the Brewer case, but it's really dicta in the Brewer case because the Brewer case says that this is not a deauthorization of a physician case. So I really don't think the prior law applies. I think it's got to be based on a statute that's in existence now, which it's not. It's not. There's no basis for them. When they deauthorized these doctors in July of 2009, there was no pending request for a change of physician by the claimant. There was no IME, no overutilization. If we get to the good cause issue, I submit there's no evidence on the good cause issue. For example, even the costs. We're concerned here about costs of transportation. There's no full evidence as to what the total cost would be. Maybe Dr. Workman would charge 3 times as much as the physicians in Florida. There's no evidence at all about costs.
Well, what about the concern about the block and the traveling after receiving the treatment?
Well, Mr. Brown testified that he had never had a situation where a claimant moved out of state and wanted to continue to come back to Florida. So he has no personal knowledge of any issues that could arise out of this situation. Furthermore, there's not one bit of medical testimony in this case that claimant shouldn't receive treatment in Florida or that it's better for him to get it in Tennessee as opposed to Florida. Mr. Brown said no one ever even asked the doctors that. There's no medical testimony in here at all that it's in claimant's best interest to get the treatment in Tennessee as opposed to these doctors that he's been seeing for years in Florida. So there's no competent evidence to support a finding of good cause if we even get there. I submit we don't even get there because there was no statutory basis for them to unilaterally deauthorize these 3 physicians. Thank you.
Thank you. Okay. Court will stand in recess for approximately 15 minutes.